And you tell me when we're on. Good afternoon, everyone. Welcome to Security Council Report. I'm Karin Landgren, Executive Director of SCR, and I'm in a conversation today with Dr. Sorcha MacLeod of Copenhagen University and of the UN Working Group on the Use of Mercenaries. Before we go any further, I just want to do a quick sound check and see whether people who are joining us online can hear properly. My colleague Vladimir is managing this and is checking right now if anyone indicates that they cannot hear. Thumbs up? All right, very good. Sorcha, welcome. You're here to discuss the working group's latest report, which I've been abbreviating as Mercenaries at Sea. Now, both this report and the working group have longer names than I've given them. So if we could start with a few basic questions about what and who are the working group on mercenaries.
Well, first of all, thank you, Karin, and your team for hosting this side event to the General Assembly. We're very appreciative of that and for you for being in conversation with me. So the working group on mercenaries is a working group established under a Human Rights Council mandate. We're part of the UN Special Procedures. And so many people are more familiar with maybe the solo rapporteurs, but working groups are working groups within the special procedures system. And we are independent human rights experts. We don't work for the UN, we don't get paid. We have other jobs. You said I'm at the University of Copenhagen. We have a mandate. We have a very broad mandate, actually. And that's to look at mercenaries, mercenary-related actors, and private military and security companies. PMSCs. Acronyms cause all sorts of problems and definitions cause all sorts of problems here. So mercenaries is the only one of those actors that actually has an international legal definition. Yeah. So we have our own definition, our own working definition of private military and security company. And we would generally describe that as usually a corporate actor that provides military and/or security services. And that could be a whole spectrum of different things. Training, we could be providing static guarding, or in the maritime context, providing security on board vessels at sea.
We'll talk more about that. But what I'm hearing is that private military and security companies, PMSCs, are not necessarily the same as mercenaries and are not necessarily unlawful. Is that right? Is it? I'll let you talk to that first, perhaps, but also tell us whether mercenarism is by definition unlawful.
Yeah, and this is where it gets tricky.
Yes.
So the definition of mercenarism is the international legal definition of mercenarism is in the Geneva Convention, Additional Protocol 1, Article 47. And it's a cumulative definition, and there are 6 elements to it. It's actually very difficult to meet the international legal definition
because it has to be 1 and 2 and 3
exactly,
and 4.
exactly,
Conditions that have to be met.
exactly. So the Geneva Convention definition doesn't criminalize mercenarism. So you asked, is mercenarism unlawful? So under the Geneva Convention, no. The purpose of the Additional Protocol 1, Article 47 provision is to define a mercenary for the purposes of combatant status and prisoner of war status. So if you meet the definition of mercenary, you are not a combatant and you're not automatically entitled to the protection of prisoner of war status. That's all that the international legal definition does. So you have to have been specially recruited to participate in hostilities. You did directly participate in hostilities, that you are motivated by private financial gain, and that financial gain is substantially more than you would receive if you were a member of the regular armed forces. Right? So quite subjective, very subjective elements. How do you prove what somebody's intention is? How do you determine what they were actually being paid for, what they were doing? And then you've got some sort of excluding elements. So if you are a national party to an armed conflict, you're not a mercenary. If you're deployed on a peacekeeping mission or other official business, then you're not a mercenary. So to come back to your original question, the definition of mercenary is very specific. And it's not helpful to think in binary terms about these actors. So a private military security company, it might never ever provide military services. It might never ever fall within the international legal definition of mercenary. However, a private military security company might be involved in human rights violations or even violations of international humanitarian law, committing war crimes, for example. So we've had information, land-based security companies where they have provided legitimate security services, for example, protecting conservation areas, anti-poaching initiatives, perfectly laudable activity. However, they have been involved in arbitrary killings of people from helicopters using heavy weapons to do so. So that people's right to life will be violated, there'll be no due process, etc., etc. So not a mercenary activity as far as international law is concerned, but still human rights violation. Now that same company, we have information that that same company will also provide military services, combatant services, and participate in hostilities. So that takes that company into the international legal definition of mercenary. Now, it's not for us in the working group to determine who is or isn't mercenary. That's for a tribunal to determine. But we can say, well, we have this international definition. It looks like they were directly recruited, that they did participate in hostilities and that they were paid, etc. And they weren't deployed on peacekeeping. They weren't nationals of the country in which they were operating. So it's more helpful to think of these actors on a sliding scale, and not to think of them as a homogeneous group.
Indeed. Maybe we'll come back to towards the end of our chat, whether the 1949 definition is still what we need today, since so much of this seems to be happening outside the context of hostilities. But let's hold that for the moment, because
Could I come back and say, because you did ask about criminalization. So
Yes.
there are other international instruments and indeed national laws that do criminalize mercenarism. So you have the UN Convention on Mercenarism, you have the African Convention on Mercenarism. Now, both of those do envisage the criminalization of the recruitment, the training, the financing, the deployment of mercenaries. The difficulty is that they use an almost identical definition that's in the Geneva Convention. So there's consistency, but it does make it very difficult. And we only have 37 state parties to the UN Convention, so it's not a widely accepted instrument. States, on the other hand, do have, in some cases, easier to satisfy provisions that criminalize mercenarism. So there are some countries where the simple act of fighting for another country could land you in trouble and be criminalized, prosecuted and convicted as a mercenary. So you don't have a very difficult cumulative sets of criteria to meet. But we don't have a lot of examples of mercenaries being prosecuted.
interesting. Let's go to your most recent report, Mercenaries at Sea, but you can give us the full name and also talk about what was the prompt for looking into PMSCs and mercenarism at sea.
It's a really good question. I think there are a couple of different things going on. So we, on the mercenary side of things, we were receiving information, or we received some information that we've seen an increasing deployment of mercenaries in the last couple of years in a variety of armed conflicts around the world. We issued a statement back in March indicating our concern, our alarm actually at this substantial increase in the use of mercenaries in these different situations, because they prolong the conflict. You've got heavy weapons being used. You've got the proxy actors being supported by states in some cases, and all of that is bad news for civilian populations. If the conflict is prolonged, greater negative impacts on civilians, and we were seeing really horrific atrocities being perpetrated against victims on land. So mass killings, torture, disappearances, sexual and gender-based violence, and in some cases, targeting of civilians, which amounted to war crimes, in our view. So we've got that's the sort of background to where we are with mercenaries. And one of the things we started hearing about from our networks was that people and weapons material were being transported by sea and supporting different mercenary operations. So that was one of the prompts for this report. I think the other prompt was that COVID-19, and this is more on the private military security company side of things, COVID-19 exposed a lot of problems in the maritime industry. And we saw the International Criminal Conduct Association, for example, having events and reports, publishing information on some of the difficulties that were arising out of COVID-19 in the maritime context. So we were seeing, for example, seafarers being abandoned at sea in very large numbers, but we were also seeing private security guards, the security personnel themselves being treated very badly, being abandoned at sea. And so it seemed an opportune time for us to be actually looking at what was going on. I think there was another prompt, and that's the fact that the Montreux Document Forum has a specific working group on maritime security, and I think they were working on their report at the same time as we were working on our report. DCAF, which operates on focuses on security sector reform, was also looking at it, and I think there was a sort of coming together of all of us who were thinking, actually now is the time we need to be really focusing on this, and I think we've been proved right on that. For example, the African Union in June this year expressed concern about the increase in piracy, for example, and piracy has been the key driver, not the only driver, but the key driver in the deployment of private military security companies at sea.
Now, we talked about many of the reasons why this was the moment to, and I understand you said earlier that the working group is independent. So were you asked by any organ to look into this, or something the group came up with?
Nobody asked us. Yeah. We decide it would be wonderful if somebody asked us to focus.
I guess what I meant was
uncertainty. No.
And you were not tasked.
No.
Come up with your own.
Yeah. And even if we were asked to do something, we as independent experts, we decide on what the issues are. So we always try to identify current issues, obviously human rights focused issues that are within the broad terms of our mandate.
Let's turn to mercenaries at sea. I just want to add that we will be taking questions from the room and from online. So if you are starting to think of questions, please hold on to them for a little bit. What are mercenaries doing at sea?
That's an excellent question, and it's one that we were not able to answer fully in the report, unfortunately. One of the key traits of mercenaries and mercenary-related actors is that they operate in a situation of opacity. There's a real lack of transparency. They operate in the shadows. That's what they do, and that's fundamental to the way in which they operate. So while we did ask, we issue a call for inputs. This is also part of the process. We issue a call for inputs. We held an expert consultation, and we specifically asked for information about the mercenary, the links to mercenarism. And we didn't get a lot of specific detail. We did get confirmation that the information we had been receiving seems to be correct, that they do seem to be involved in, or there does seem to be a maritime element to transportation of persons, which in some cases may amount to trafficking. That mercenary recruits, particularly from conflict-affected areas, might in fact themselves be victims of trafficking, that they've been recruited fraudulently, or they've been recruited under duress, threats made against the family, for example. And we also got confirmation that weapons material do seem to get transferred at sea for mercenary purposes, but we just don't have the data on that. And so the report focuses much more on the PMSC side of things, rather than the mercenary side of things. And it's an unfortunate aspect of the work that we do, that we can do research, we can ask for inputs, we can consult experts, but if the data is not there, then we're in a position of saying, well, our message then is we need more data. Yeah. We need to understand this phenomenon better. Tell us about what's going on, and then that's when things like the communications procedure that we can use, where we can receive submissions to issue allegation letters, that then becomes a valuable tool for us, because that then feeds into future reports. But we on the mercenary side, we have limited information.
Very hard to know what's going on.
Yes,
especially as it's at sea. Yeah. But what is going on seems mainly not to be military services, naval warfare type thing. Although there is a reference in the report to an incident that the Libya panel of experts talked about in 2021. I think, was it called Project Opus? Exactly. Can you say a word about that?
Yeah, so this was an interesting example from the UN panel of experts on Libya, and they pointed to an attempt to circumvent various embargoes and sanctions, particularly around the transfer of weapons and material into Libya. Now we've in the working group we've issued several communications, allegation letters, and statements about the involvement of mercenaries in the Libyan context, that they have committed human rights violations, IHL violations, that they have undermined the peace process in Libya. But the panel of experts cites this particular example where several individuals from a variety of different states, so they satisfy that foreigner element of being a mercenary, who were quite advanced in preparing for maritime interdictions. So they had gathered a strike force of speedboats and attack helicopters that were going to be deployed at sea to undertake searching of merchant ships. And I'm just quoting the panel of experts. They said that the Security Council resolution 1970 2011, that what was being done was in breach of the arms embargo in paragraph 9 of that resolution, because the individuals were supplying vessels that met the definition of military equipment, and that resolution explicitly includes prohibition on the supply of mercenaries. So that's really the only example that we have, but it does point to the fact that, well, it's happening. They were stopped in that, they were stopped in that particular instance.
It's interesting. The report really is an interesting read, I have to say. So anyone who hasn't read it and wants to look it up, A/77/268 of August 4th this year. But I think you just presented it last week.
Just this week, actually, Tuesday morning this week at the third committee of the General Assembly.
So it's just been launched.
Just been launched. Yes.
You also mentioned in this connection floating armories. You say that was one of the things that caught my eye in the report. You say a word about floating armories.
Yeah, floating armories are a really interesting phenomenon, and the information that we received in the inputs, written inputs and written submissions, which are on our website, if people are interested, we received inputs from civil society, but also from several states. Floating armories came through very loud and clear, also in our expert consultation, as being something of particular concern. So for those who don't know, I know there are people online who are well aware what floating armories are, but maybe some people aren't. And these are vessels that are moored outside of jurisdiction of states that are used for the management and storage of weapons. And the information that we received really pointed to a lot of concern about the safety and security of these types of vessels, that they're very vulnerable. And I think this was highlighted as a well-known example where an individual, and this was during COVID-19. As I say, COVID-19 really exposed a lot of issues. So an individual, if I remember correctly, he had not been paid. He was a security guard on a ship. He'd not been paid, and he was deeply unhappy about this. I think he just actually assaulted another colleague, and he'd been taken off the ship and put onto what was essentially a floating armory to be sent home, essentially. And he took the floating armory hostage as a way to get leverage to get his back pay. And now he was ultimately prosecuted in his home state for piracy, actually. But I think it just shows one person was able to take control of a significant amount of weapons, which I think just underlines the concern about floating armories. So one of the recommendations we make is that these are outside of the regulation and of states, and it would be much better if you're going to have weapons. Then they need to be secured, and it would be potentially better to have them on land if possible, where they can come under the jurisdiction regulation of a state, rather than these free-floating armories.
So let's talk a bit about victims, because if we think about PMSCs out there protecting against piracy, maybe they're the anti-pirates, maybe they're protecting undersea cables or pipelines. They sound like they could be the good guys in this context. So who are the victims who we're concerned about them with regard to PMSCs and mercenaries at sea?
I think that's a really interesting question, because our other thematic report that we just presented this year to the Human Rights Council, I presented it in September, is actually focusing on victims of mercenary-related actions and PMSCs, and we adopt the broad UN definition of victim as anyone who's harmed, essentially. And most of our previous reports, almost all of them, have focused primarily on victims in the sort of very classic human rights sense, of local communities, for example. And so you see that in our allegation letters in relation to use of mercenaries in Central African Republic or in Libya. But what we've been seeing with the new phenomenon, in this new way of the way in which mercenaries are being recruited, we've actually been turning to the recruits, as I mentioned earlier. So we've seen some suggestion of human trafficking, for example, and we've seen what we call predatory recruitment.
So they themselves are.
Yes, and that's a really sort of different angle to be looking at that. And I think within that overarching shift, and again, because of COVID-19, what we started to see was actually there were a lot of labour rights violations going on, and labour rights as human rights are our concern. So we saw the security guards themselves being victims, seafarers being the victims of security guards. But you've also got another category of victims, and that's the people who are perhaps being detained at sea or killed because they're being suspected of piracy. And so
Being killed by
security, or well, specifically PMS. Yeah. So we've got a whole set of people, and we think about why people turn into piracy. They're perhaps coming from a conflict-affected place. The socioeconomic circumstances are very poor. So you've got a whole lot of drivers behind piracy, development issues, post-conflict issues, socioeconomic issues that need to be addressed because they're the drivers of piracy. And the increase in piracy is in turn driving the use of PNSCs in the maritime context. So you've got multiple layers of victimhood there, I think we say.
You maybe linked to this, you talk in the report about a trend towards the hybridization of security companies. What do you mean by that?
That's something we've seen it. We've addressed hybridization of security in other contexts. For example, in the report that we did on exploitation of the use of PMSCs, particularly in the exploitation of natural resources or regarding exploitation projects, mining projects, etc. And there we've seen increased partnerships between public security providers and private security providers. And that gives rise to all sorts of problems when it comes to accountability. Who's in charge? If you've got police officers who are, by day, they are police officers, but by night, they are then employed privately, moonlighting as security guards. Or maybe there's a memorandum of understanding. It might be a very formal relationship between the public security provider and the mining company. So we've highlighted the problems there on land. And so what we saw with the maritime sector is that this is increased. There are multiple layers of hybridization. So we have one example is where a state is itself providing private security, is using its navy to provide private security to merchant vessels. One example. And then we have other examples where you have public and private security working more in the way that we see on land. And the same issues arise about who is responsible for the activities of the private security provider. What happens if they violate human rights? Where does that leave a victim? Who do they turn to in order to get access to justice and remedy? So this trend towards hybridity or hybrid securitization is one that's, from a human rights perspective, very concerning.
Thank you for that. I want to ask you one more question before I check if anyone in the room wants or online wants to ask anything, and before we go on to what is to be done about all this. But the question I have to ask you is, I was stopped short by an expression in this report that I don't think I've ever seen in any prior officially we went with court, and that was the use of the expression bottom feeding. We might do a check to see if anyone else has used that. What are you talking about when you talk about bottom feeding in this context?
Yes, perhaps not the most official sounding language. So in this context, what one of the things that we're seeing with the maritime security sector is that as there has been this turn towards private security, there's increasing competition, and with increased competition, we've seen that being accompanied by a lowering of standards, like lowering of pay, lowering of labor rights. And what we're seeing is that ship owners in particular, they have a very important part to play here. We haven't talked about them so far, but the ship owners who are hiring the private security providers have a big responsibility here. So if you go for the cheapest option, you're not necessarily, you're probably not getting the best quality option. And again, COVID, we saw what happened. Saw what happened there. So when we talk about bottom feeding, we're talking about ship owners in particular seeking the best, the cheapest security for the lowest price, just to say, yeah, we've got security. And from a human rights perspective, it's a disaster that they are going for the lowest common denominator. And you've got different regulatory regimes as well. So different states have different rules. There's a plethora of different international organizations that have tried to put in place some minimum standards on what should be in place when you hire a PNSC for the provision of maritime security.
But as a ship owner, you might go for the lowest.
Exactly, and we're
lowest level of regulation, lowest cost.
Exactly, and we're not looking at binding regulation there. Of course, if you've got a company that is a member of the International Code of Conduct Association, for example, then that company, if it has certification, it will go through a third-party certification process and then receive certification from ICOCA. Now, that on the face of it, that's a good thing. Any more regulation, higher standards, always a good thing. But there are problems with using third-party certification, because the security companies themselves are paying for the certification. And so again, you might go for the cheapest option, and too many security companies use auditing or certification as a tick box exercise. We haven't, it's not all, but unfortunately, a significant number do treat it that way, and they need to move on from that. They need to think about it as an ongoing process, not just a snapshot of what they're doing on that particular day when the auditors.
And we're going to come back to different sets of recommendations that you want to make to the different actors involved in this. My last word on the bottom feeding is that it is actually a very apt maritime metaphor, so I'm sure you thought that through. I just want to check if anyone wants to ask a question here or online. Yeah, please. I just asked you to speak now,
Yes.
because it needs to be captured by this little owl.
Thank you very much, Sorcha, for the presentation, and thank you very much, John, for hosting us here. So this is Esther from the French mission. I covered a lot of things, but to be brief, but I think that what you said about operating in shadows really resonated, because that's exactly what we are confronted with, and it's very difficult for us to approach. And I think that collectively, what we've been trying to do to work on these threats is to use a multiplicity of instruments to, if there's something in a black box that you can't control, then you try to take as many angles as possible. And so, what came to mind when I was listening to your presentation was, for example, arms embargoes. You mentioned the one in Libya, But for example, one of the reasons we were able to very quickly react in CAR was because there is an arms embargo, and when we had received through that sanctions committee notifications that there was going to be state assistance in structures, and then over the course of the first month of the year 2021, it appeared that there were maybe Arabic native speakers that were deployed in CAR, and so there was one first line of attack to question the reality that was happening. But there's not embargoes everywhere, and so we need to every time to try to see what the best way to approach things. You mentioned human rights, and that's also a very strong angle, especially in countries where there are UN missions, because, for example, in Mali, it raises a very big issue of HRDDB, because when the mission is mandated to work with local forces to help them provide support, fuel, etc., and when there is a doubt about, mercenaries or PMSCs, I agree with you that the labels are very difficult to navigate. Then, what does it mean for a mission to be giving fuel to the host country when there is a doubt? And so that's, an issue that we didn't have to think even 1 year from now, but that's now all of a sudden we need to become experts in this type of instruments. I also thought of in the accountability report, there is a whole section on resources, and so it leads us to thinking of other initiatives such as the Kimberley process. That's not supposed to be on mercenaries, but it's on transparency. And so how can you use, we need to be creative. And so if you have recommendations on what are the ways we can collectively address these new emerging threats, that would be my first question. And the second comment I wanted to make was, we need to be tough on the bad ones, but also promote the good model between inverted comma. And so I think that all the issues that we've placed on the table today and in your reports, they show to us also what is the cost of inaction. If we are not able, for example, I'm thinking of financing of AU operations, for example, if we're not able to make a sustainable model, a virtuous model, and to create this virtual connection where if you commit as a country to respect certain standards in terms of respect of human rights, then you can expect more support from the international community. And so it becomes not only preferable, more efficient to be respectful of human rights, but also more interesting. So that's also what we are trying to push. And for example, now there is a project to develop the EU compliance framework. And I think that it's an initiative that we need to make more, well-known and supported, because I think that's part of the solution is to also work on the incentive aspects of it.
This takes us nicely into the question of what are your recommendations and for whom, but I have to say that I like your illustration of either using a range of instruments to box in the problem areas, or as I'm seeing it, kind of throwing up different sorts of roadblocks to the different problems. It's a pity there isn't one and done instrument that will do this. But I don't know if the best way of doing this is to walk through recommendations for states, recommendations for the companies, and so on. Maybe we start with recommendations for states.
Yeah, I'd like to come back a little bit on what Estelle was saying, and I think if you're talking primarily, not entirely, but primarily about mercenary activities on land. And as I said at the beginning, we have this huge black box, as you called it, of we know that there are mercenary activities at sea. We've got a lot of detail on what PMSCs are doing. We've got quite a lot of information about that. On the mercenary side of things, we really have very little information. And there are certain specificities of the maritime context that really exacerbates the black box. They really, make that black box enormous. We were talking earlier, and I was saying one of the we don't have oversight and regulation by states at sea because it's in some ways it's impossible. Doesn't mean we shouldn't still try and have better regulation, and that's certainly one of the recommendations that we make, and I'll talk about that in a second. But I think another really important thing to remember about the maritime sphere is that we don't have monitoring and oversight from civil society. There is no civic space essentially in the maritime sphere, and I think that's also hugely problematic, and I think we need to acknowledge that there's a huge gap there. There are some civil society actors that are trying to fill that gap, but they do acknowledge that it's very difficult to get information. So I really like the idea that thinking at this strategic level and thinking creatively about solutions, I think is absolutely essential. I don't think there's any question of that, and I'm really glad to hear that France is thinking in those terms. State recommendations, well, better regulation. Again, on the PMSC side, thinking about the recruitment processes, better vetting, better training for private security personnel, and that's absolutely fundamental. Particularly training on the use of force, because the information that we received was that most of the human rights violations, or a lot of the human rights violations that are occurring in the maritime context, are due to unregulated use of force or excessive use of force, use of weapons. So we want to see a regulatory structure that has better training on use of force, better weapons training. That's absolutely fundamental, and especially given what I was saying about the floating armories, weapons training, I think is hugely important. We also need to ensure that there is effective monitoring and oversight of what is going on in the maritime context to fill the gaps that we've been talking about. And the thing that is most problematic is not knowing who's actually in charge always on the vessel, and that comes back to the hybridity problem. So having consistency and clarity about who's responsible on the vessel.
Is the use of flag states a problem in this context?
Yes, and again, that we'll come back to bottom feeding again. Potentially, we're seeing states. Potentially we're seeing ship owners gravitating towards flag states that have the lightest touch regulatory environment in those terms. So that we need to be focusing definitely on the flag states.
Is there scope for, when we talk about essence, establish the idea of a virtuous model? Would there be a way of incentivizing a virtuous model on PMSCs?
Well, this is where multi-stakeholder initiatives have a really important part to play. And one of the other recommendations that we make in the report is that states should become members of the Monterey Document Forum. I think we have about 57. I'm looking at this with the delegation in the room. I think we're on 57 member states, give or take, plus some intergovernmental organizations.
More than our party to the convention.
More than our parties to the convention on mercenaries. But of course, the Monterey document is more focused on specifically on the private military security side of things, and specifically references PMSCs. It doesn't mean it's not relevant on the mercenary side. But I think that's one way for states to build their technical capacity, to be supported in developing regulatory mechanisms that will address these issues. And then, of course, well, you know, we've got an International Code of Conduct Association. I've mentioned a couple of times. I know Jamie's in the online, or he was earlier, and I know that ICOCA has both land and maritime companies. Is the International Code of Conduct Association for Private Security Providers, and so you know that is a multi-stakeholder organisation. I don't want, sorry Jamie, forgive me if I don't want to get this wrong, but it's a multi-stakeholder organisation that certifies private security providers. So they do the audits, they are audited by third-party providers and then get certification, or can get certification from the association. But there we only have 7 state parties. I think we're about 100 companies now, which is, you know, it's not insignificant, but there's a lot of work to be done. And but if you work at the working group's perspective, we think that there should be international regulation. We've been very active in the open-ended intergovernmental working group on creating an instrument for private military security companies. And we've been making sure, we've been part of an effort to make sure that a couple of things happen. One, that it addresses land and maritime security provision, but also that it provides routes to effective accountability and effective access to justice for victims. And we've just seen the second draft of the instrument. We don't know yet if it's going to be a binding instrument, and this is it's problematic. It's sort of trying to be both binding and non-binding at the moment, which is a little bit tricky. I call it Schrodinger's instrument. It's both a treaty draft and not a treaty draft at the same time. And of course, the working group's position is that we want to see an international regulatory instrument that is human rights, that centres victims, that centres accountability and access to justice for victims. But ultimately that is there to improve standards across the board for the security industry.
I think we might have one question
Yeah.
from Peter Cook.
Hello, Peter. Hi.
We just have time for that one question. Do you, can you speak, or do you want to?
Yeah,
read
you
out?
can speak now, Peter.
Hello, Sorcha. Excellent report. I think it's very good. You found out a lot of good stuff, and I have no problems with any of the accuracy on that at all. But one of the questions I do have is, we were very aware that floating armories were a vulnerable point in which things could go very wrong. And with the help of a flag state, we were able to propose to the IMO that they built, or indeed we added a form of regulation within the ISO 28007 that meant that the floating armories had to comply with a similar set of rules. It wasn't perfect, but it was a starting point upon which we could build. The IMO didn't take it forward. They passed it on to the International Contact Group, Piracy Off the Coast of Somalia. They didn't do anything. It went back to the IMO. Therefore, part of the problem in a number of things that you have talked about, as with rules for the use of force, the states have been reticent to actually take on responsibility to be able to provide a regulatory structure that will protect all the various stakeholders that you're talking about. And indeed, it is dependent upon all the stakeholders to contribute to this to make it work. But when some of the stakeholders, whether they be states, ship owners, insurers, or flag states, don't contribute, that's where this falls down. Would you agree with what I'm saying there?
Thanks, Peter, and I'm very glad you like the report. That's very much appreciated. I think it was one of the things that was when I was doing research for the report and looking at the IMO's position, how it's shifted and changed. I hope it's reflected in the report, that the IMO sort of went from a very clear position on no, private security shouldn't be used on maritime vessels, and then it sort of slowly shifted towards, well, if you do, then you should sort of use effective security and try and meet some criteria. It feels like there's a lot of hesitancy, as you say, in relation to states, and I think that comes through in the IMO's position. But yes, I would agree with that assessment that there's a great deal of hesitancy, and I think it comes back to the specificities of the maritime context. It's sort of very much out of sight, out of mind, and I think one of the things that was really important for me and with this report was to essentially shine a light on what is a very murky part of the security industry, and I think particularly from center victims as well, because ultimately they're the ones that are suffering as a consequence of states' hesitancy to properly regulate in our view. So yeah, I don't think we would disagree on that at all.
Thanks so much. We're going to need to bring this to a close, but it's been great talking to you, and I've been struck by how much mercenarism has been in the news in the last couple of years, but land-based. This is an issue that I have certainly not thought about before, and I found your report an eye-opener. So thank you and the other members of the working group for looking into this, and thanks for coming to have this side event with Security Council Report.
Thank you, and thanks to
Thanks everyone who joined us.
and online as well.
All right.
Appreciate it. Thanks.